you think there are any grounds on which equity would allow a district court to excuse noncompliance with a 30-day removal deadline other than the exceptions that are set out in the statute? Are there any non-statutory equitable exceptions to the 30-day rule?
It's possible that there could be some estoppel. There cannot be equitable tolling. It's possible there could be estoppel, but that isn't an issue here. It's not an issue that Enbridge has raised for good reason.
If estoppel would permit removal after the 30-day period on equitable grounds, then that does seem to say that we have to look beyond the statutory text and see whether what is alleged here might possibly qualify.
This court has said that equitable tolling and estoppel are distinct doctrines. It said that in Beggarly. And this court has typically deferred, as it did in Ariano, the question of estoppel because especially if it's not raised in a case. It was not raised here. It hasn't been briefed before this court. And it's hard to see that equitable estoppel would—
No, I'm not suggesting that this is a case in which equitable estoppel would excuse noncompliance. I'm just asking whether you have to agree, if you recognize that equitable estoppel might excuse the late filing of removal, that equity might possibly extend further to other comparably egregious situations.
I'm not suggesting that equitable estoppel would apply. I don't think it would apply to this removal statute. And the reason I say that, I just bring it up as it's not something the court has considered. It's a separate question. I don't think it would apply here. And I say that because there is so much, there's so many equitable considerations that are already built into this statute that this court might well decide if estoppel was briefed and before this court that it didn't apply.
All right. Well, thank you. Let me ask you one other question, at least for now, and that is, I would be interested in your response to the arguments that are made by some of the amici about the consequences for U.S.-Canadian relations if the state court orders that operation of the pipeline be terminated. Those are spelled out in the West Virginia brief. They're pretty severe. And Mr. Bursch made the point that if this proceeds in state court and the state court issues a preliminary injunction against continued operation of the pipeline, it could be a long time before the issue could be, this issue involving treaty rights, which is a federal question, could be reviewed here. So what would you don't really address that, so what would you say to that?
When Congress wants a kind of case or a kind of issue to be decided in federal court, it mandates exclusive jurisdiction. And otherwise, state courts have concurrent jurisdiction. They have reserve power under the Constitution to adjudicate cases in their own courts. This is a state official, state claims filed in a state court. Congress, when they set up the removal process—
So the answer is it's just too bad. And maybe that's the answer. Sometimes the law produces consequences that are not desirable. But what we're told, this is in the West Virginia brief, they're quoting a Canadian source, shutting down Line 5 would result in a massive shortage of gas, diesel, and jet fuel in both Ontario and Quebec, not to mention end thousands of Canadian jobs. A special committee of the Canadian Parliament concluded that Line 5 shutdown could reduce safety, create shortages of various energy products on both sides of the border, et cetera, et cetera.
The state's position is that these are state law claims. None of those considerations are at play here because we trust state courts to adjudicate issues, to even federal questions. They've been doing that since the founding, and we trust them to do that with this court's backstop. If something goes really awry in a state court and it's an important matter of federal treaty. It hasn't been given exclusive jurisdiction in the district court. This court can review that and can fix that. But we trust state courts to do their job and to have concurrent jurisdiction. And one of the reasons there has been a tradition of strict enforcement of the removal deadline here is out of respect for state courts. And this court had said over and over in a long line of cases from Babbitt versus Clark on that when the deadline is missed, remand is necessary. And this court has said that strict procedures, the statutory procedures for removal are to be strictly construed.
Counsel,